Good afternoon, Helena. Welcome to the cave. We're so happy to have you here. Thank you for making time. Before I ask you to introduce yourself to all the designated social workers who'll be watching this recording, I just want to let the designated social workers know what today is going to be about. Today's bonfire chat is about two specific sections in the Children's Act that you, from your expertise and your experience, believe that sometimes the designated social workers forget. And we are here today to just talk about those two sections and remind them of the importance of those two sections. And then we're going to talk about a very interesting and a very serious topic, and that is, when may a designated social worker interview or talk to a child without the consent of parents, and when is it absolutely essential that consent is obtained before talking to children? So those are the two items for this bonfire conversation. We're very excited and very grateful to have you here. But let me keep quiet. And Helena, if I can ask you to just introduce yourself, tell the designated social workers who you are, your experience, your qualifications, your current position, so they know that they can trust what you say.
Good afternoon. I'm Helena Burke. I'm a social worker by profession, being in the CPO business for more than 30 years.
Oh.
In the meantime, I've also done an LLB, so I do understand the mindset of lawyers and presiding officers, and that makes a big difference. I've been a supervisor since 1991, so it seems like I might be one of those that stuck to my guns where it is about protecting children.
Oh, that is brilliant. And how fortunate we are to have basically a designated social worker with 30 plus years experience in practice. But on top of that, because we often interview attorneys on the cave because we need to learn from them for sure. But here we have a designated social worker with an LLB. So I hope that the designated social workers are excited to hear what you have to say. I've recently attended your training. I respect your opinion and your interpretation of the law very much. So thank you so much for being here. All right. So the first question, Helena, is two sections of the Children's Act that you think sometimes we forget about and that we shouldn't forget when we do the work we do.
I think sometimes we forget what our main aim is, and that is to promote families and keep them together. And we should do anything in our power to do that. Yes. But now we land in court. And what we tend to forget is what evidence is. That our reports, although they are prescribed, if we look at section, let me just see, section 62 and section 63 of the Act, it tells us it gives us a lot of information where this is concerned. So we tend to think that my report is the only report in front of the court. Professional reports ordered by court can be a family advocate, a psychologist, a doctor, any other person that the court wants to have information in a report about as well. And not only social workers can bring the reports to court, and we tend to forget that. We use other people's professional reports and ignore what they tell us. So sometimes we must forget about our own idea of what evidence is and see it from the greater picture that is outside. When we look at evidence, what is very important is that social workers should not forget that what I give to my client, I'm trying to be this sympathetic or empathetic that we actually should be person, and I tell them, you know what, I've had this same experience. A family member of mine also went to rehab. I am a divorced lady with children that have problems and so forth. We think that builds rapport. It gives your client enough information for their evidence to become part of the court proceedings. So we shouldn't share what we think the client is going to want to hear to decide their cooperation with us. So what we tend to do is now we're giving the client and the lawyer information about us, me as a designated social worker. And then the court, when they receive this report, realize, but here are other evidence in front of the court. Other evidence that puts us in a position that we might be seen as either biased or not objective.
So what I gather from you is one practice tip that you'd like to share with the social workers is that we must remember evidence, and that when we overshare and over disclose with our clients, it would ultimately come to the surface in the courtroom, and that could be used as it could be seen as an opportunity to accuse the social worker of not being objective, which is key in child protection investigations. Excellent. Yeah. So definitely. And I think, we also teach students at university that there is a time and a place for self-disclosure, but ethically only if it is helpful to reach the aim with a client. But one should be very cautious in that, because ultimately it is about the client. It's not about the social worker. Yes.
Yes, I would think the difference would be when I do disclose something about myself, it would be in therapy.
Yes,
when
yes.
no one has the right to know what's going on.
Yes.
But over here, it's not the same. So pick your place.
Yes.
Where it is applicable. And it's not applicable when you do investigations for a court and you present evidence to a court.
Very, very good point. Yeah, excellent. Yeah.
So if you look
No, carry on.
No. If you look at the content of the report, it doesn't state anywhere what your feelings were about the situation.
Yes.
It gives you the opportunity to evaluate the information with the background of your training and your experience.
Yeah.
But nowhere it says the social worker gave the following information for the client to make the decision in the end, in the best interest of children.
Absolutely. Is there a particular section in the Children's Act that relates to this topic of evidence that you want to bring to the attention of the social workers?
No, I just think they should look at section 63 and 64 of the Act.
Yes.
62 and 63 of the Act.
Okay, 62 and 63. All right.
Yes. Just read it. It doesn't give you what we've spoken about. Yeah. But if you interpret it in that
light. In that context. Let me just have a look here. Yeah, so 62 is your professional reports ordered by court. And is 63 is about evidence, yes. So maybe those are two sections that we can also maybe summarize here at the cave. We do have a component, moonlight. Maybe I will do that for the designated social workers. They are normally burnt out and overworked. So, but thank you very much. Anything else? Yes.
Yes, and then I just tend to forget that we actually have section 151 at our disposal. Removal of children by
court order.
By court order.
Yes.
We tend to think, we spoke about the cowboy social workers that would go in and remove. That should be applicable when it is about abuse, and especially then sexual abuse.
Yes.
But when it is a normalized, and social workers would know what I mean when I talk about a normalized situation.
Yes.
Go the other route. Go the other route to ensure that we have the ability to render intervention services. So that would be another one that we tend to forget.
Yes. Okay. Yeah. So to summarize, two sections of the Children's Act that you think designated social workers must just be reminded of today, it's section 62 and 63, in the context of what evidence is and how social workers must be careful in their work with clients during the investigation. It's not a therapeutic process. It's a statutory investigation, no self-disclosures. That could be because it could later surface in the courtroom, that could be used against you as not being objective, etc. It could serve as evidence. Is that what you're saying?
Yes.
Okay.
Yes, that's what I'm saying.
And then the second section, section 151, although I think we all know about section 151, but perhaps some designated social workers forget that you don't always have to remove a child with a 152 in the Form 36. That is truly in situations when the child's life is in danger, and if the delay in obtaining a court order could cause harm to the child. Otherwise, if it's not the case, use the section 151, write your reports, and let the court participate in the assessment and decision-making processes.
Yes, that's exactly. And remember, 151 is read with section 50 that says to you that the court can appoint you and give you lots of rights. You can enter someone's premises with that order.
Yes.
Where if you try to do a 36 and you can't, you have to get the police involved.
Yes.
With all that trauma regarding in those circumstances. So to minimize the trauma of the children, sometimes we just need to apply our minds.
Yes.
And take into account.
Section 151. Thank you so much, Helena. The second topic is about designated social workers interviewing children, talking to children. And we recently had this conversation at a training you presented. So some designated social workers seem to have come into a lot of civil problems with civil suits because they interview children without consent. Maybe you could just give a bit of context and then just educate the designated social workers legally what may and may they not do.
Okay, consent is something that's extremely interesting. There's a lot of it to say in the law of persons, but if we look at especially then the Children's Act, it would be section 18 says, whenever more than one person has guardianship of a child, each one of them is competent, subject to subsection 5 or other law or any order of a competent court to contrary to exercise independently and without the consent of the other right or responsibilities arising from such guardianship. That says to me that both parents have the right to give consent without the consent of the other.
Absolutely.
Yes. And then if you look at section 30, it also says where more than one person holds the same parental rights and responsibilities, each of the co-holders may act without the consent of the other co-holder or holders when exercising those responsibilities and rights.
So you need the consent of at least one parent, but I think
at least one parent.
At least one, or caregiver, or someone with guardianship. But I think some designated social workers might say, but you know, when we get a call and there are very serious allegations and it requires of us to investigate, and that investigation would include speaking to a child. Say, for instance, the child is 13 years of age or 12 years of age, totally capable of conversing with a social worker. Are you saying that the social worker first needs the consent of one of the parents to have that conversation, even if the parents might be possibly the accused?
That is where we should use our court, because our court says when you need that, and that is why if we look at section 151 and 50 and 46, it says I can approach the court to get that consent.
Okay.
Because it can give you the right to approach.
Yes.
But sometimes we forget. What we do, sometimes this is not practical, but if a school, for instance, calls you, call the parent, say the school has a problem with a situation, or there might be something wrong, or let's meet at school.
Yes.
Meet at the school, and then one can explain to them what it is and why we need their consent. Because as you say, the civil suit, it might be a problem.
So the bottom line, as a designated social worker in this country, taking into context all the legislation, you cannot simply approach any child and just start up a conversation for professional purposes. You would need the consent of one of the guardians. If the parents deny you that access or consent, and it's of importance that you do speak with a child given the report or allegations, you can approach the children's court for a court order, giving you that kind of permission to speak with a child.
We must also remember that as the rights of the child is also part of the Constitution, and the best interest of the child is paramount, sometimes you have to do immediately, and if you really dealt with it in good conscience, you can weigh up those situations and decide it's the best interest of the child that I can or have to speak with the child without the consent of the parent.
Yes.
I would just like to quote the South African Council for Social Services Professions General Notice 6 of 2002, where it says that we have an ethical responsibility towards the client system and that consent is supposed to be part of that. But services to children without the consent of the parent or the knowledge can put you in a bad situation, but you can follow the interrelated principles. Firstly, obtaining parental consent. If you look at the need to social workers, to social services need to be respected, you can do it without the consent, and then always remember that the best
We lost you there for a second, Helena. Are you back?
Oh, am I back?
Yes, I can hear you.
Can you hear me?
I can hear you, but I think we got the gist of it. So I just want to ask you, maybe you can share with the designated social workers without, disclosing any identifying details of what has happened to a social worker, designated social worker, when she interviewed a child without the consent. Just so the designated social workers understand. And this is not to drive a fear campaign here. It's like you said, we need to use our professional discretion. If there's a situation and talking to that child immediately is in the child's best interest, it'll allow you to make a better informed decision. Say, for instance, the mother's intoxicated or the father's violent. And you need to speak with a child, that can be defended and on the basis of Section 7 and Section 9 of the Children's Act, the best interest of the child. So it's not to say that if there's a situation, a child's life is in danger, that you're never going to speak to the child if the parents don't consent. If there's an opportunity, you approach the court for that permission. But if it's sometimes 8 o'clock at night and there's no court and the situation is of such a nature that you need to hear from the child, you proceed, obviously writing your process reports to just document everything that happened. Do I understand you correctly, Helena, from a legal point of view?
Yes. But now we must remember, SAPS, a member of SAPS will have more rights than the social worker.
More rights
so
to speak to the child without consent. Yes. And
we sometimes tend to forget that.
Yes.
If you really have a situation where you feel things might turn out completely wrong,
yes,
try to get a police officer with you. They've got more rights than we have.
Because they are legally protected to interview or communicate with citizens without consent. It's their authoritative right. Okay, excellent. So that's also a good practice tip for the designated social workers out there who don't know. If you're in a very heated situation, child's life is in danger, guardians are refusing you to speak to the child or they are incapacitated, make sure you've got a good connection or network with the police and have a police officer ask the questions so that you can get the answers you need or the information you need. Okay, that's...
I would just like to say something more.
Yeah.
We tend to forget that the child should consent to any medical examination.
Yes.
So when a child, and that is, I can give you it's in section 142 of the Children's Act, and the regulation that it talks to is section regulation 38.2.
Okay.
A child must, prior to his or her being examined or assessed for purpose of establishing whether it's been abused or neglected, consent to that assessment or examination. And we sometimes forget that.
Is that, okay, so now we're talking about the J88 in cases of sexual abuse or physical...
No, not the J88. Remember, J88 has nothing to do with the Children's Act.
Okay.
That would be as far as a Form 7 is concerned.
Okay, all right.
Because, the police with the sexual offences would do the J88.
Yes.
And that also says when the victim is a child, the investigating officer must explain the necessity of the examination to the parents or guardian of the child and obtain their consent for the examination.
Yes.
So we tend to forget that there are other acts.
Yes.
And other prescriptions in the act that we need to follow.
Yes, but I mean, in any sense, whether it's a J88 that involves a medical physical medical examination, whether it's a medical examination for whatever, the child needs to consent to it. A child can still say, I've personally had that, where children say they do not want to be subjected to the J88 or the medical examination that's reported in the J88. Although, but you're quite right, there's other pieces of legislation that govern over different situations or that also speak to the situation that social workers must remember. But maybe, but can you just share with the designated social workers what happened to a social worker that you know of who spoke with a child and what happened?
A few years ago, we had a social worker that went to school to see the child because the school reported that. That is usually the circumstances that we work under. In the end, and I think that is where our council got involved, because that social worker was reported to the council for unprofessional conduct. And the anguish that the social worker had to go through because she thought she did the right thing. And in the end, it caused her to be investigated by the council for unprofessional conduct. So we must be very careful when we decide and how we decide to address any situation that we get. And people tend to forget that we've got immense power, actually, in terms of the act, but we don't always keep the responsibility that we have in our mind when we make decisions about it.
So it was a new intake.
Yes, it was a new intake.
A new intake, get a call from the school, social worker goes over to the school, speaks to the child. And that is, I think many designated social workers do that.
Yes.
So, yeah, sure.
And many of us have done that. And it was never an issue.
Yeah.
It was never an issue. But if there is only one incident of this happening, we've got problems.
Yeah. You mean if it's been reported or they go to an attorney and they sue, etc., etc. So then it's, it's a precedent. So, so just be more cautious, designated social workers, when you do get a new intake, get the parents involved. And if there's challenges in that regard, approach the Children's Court, Section 151, and empower yourself like that to do the work you need to do. Because social workers, designated social workers, must speak with children. And I mean, that also honors, I think it's Section 10, the voice of the child. I mean, how will the voice of the child be honored if the social worker cannot even interview the child? But we as designated social workers just need to be aware of the how. and the legalities around it. And that also speaks to the rights of parents, you know,
Yes.
to say, no, you can't speak to my child, and then fight it or oppose it in court, get legal representation. They also have rights. So that objectivity must also be kept in mind, that parents also have rights.
The person with the least rights in this whole situation is the social worker.
Yeah.
You only get rights because you are appointed to do the investigation.
Yes. Yeah. Okay, no, excellent. Okay, good. So, Helena, you have really, I think, if any, you know, young new designated social worker or a burnt-out social worker who's been in the field for a couple of years, watch this. Maybe just a reminder, and for the new colleagues who are entering practice, this is a good, you know, wake-up call in terms of when do you speak to a child, the consent issues, and then all the relevant legislation or sections that you mentioned. And then specifically the idea of evidence, and the designated social workers must be very careful with self-disclosure during an investigation. And that is actually only applicable in a therapeutic process, and also only when it is going to actually help the client. So yeah, is there anything else you'd like to add before we conclude this conversation?
No, I just think seeing that we have lots of social workers in this field for more than 10 and 20 and 30 years, don't give up.
Yeah.
You can make a difference, even if it's in one child's life. So never give up, and do the good work with the backing of your own conscience and your own sense of doing things right or wrong. We know what to do. We know how to do it. Don't let something be so big, like a tsunami. The only way that happens is when you allow that to happen. I know we overworked, I know we overburdened, and I know we sometimes feel we don't know what. But sometimes just go and sit and think about the one child that I can make a difference to in my life will give you the energy to do it again and again and again.
Absolutely.
So it's one child.
Absolutely. And if they do make mistakes, we are all only human in the end.
Yes.
And you know, apologize, fix the mistake, get up and carry on.
I agree with you completely.
Helena, thank you so much. I know that you're a very busy supervisor and you train people. So thank you very much. Really, it's an honor, and I hope that we can chat again here at the Cave about some other legal issues specifically, since you have an LLB, which is really you know, very impressive. So thank you very much, and I hope that you have a wonderful weekend further.
Thank you so much.
Bye-bye.